All right, we are live and on the record.
You're up, Megan. Don't go yet.
Oh yes. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you. And good morning, and welcome to the Massachusetts Appeals Court oral argument session for May 15, 2020. I'm Greg Massing, and the argument is being, the panel today consists of Justice Shin, Justice Ditkoff, and myself. As you know, this argument is being held on Zoom and live streamed on the Appeals Court YouTube channel. We follow the same rules as in the physical courtroom. Each side has 15 minutes to argue. We'll ask questions. There's no rebuttal. Only one of you will speak at a time, and the clerk will mute the other one until it's your turn to speak. She'll also be displaying a countdown clock once you get going. The proceeding is being recorded, so anything you say during this proceeding will be heard by all those observing and become part of the record, just as in the physical courtroom. If we have any technical problems with the connection, we might have to stop the argument and even maybe put you in the waiting room. Hopefully that won't happen, and we'll have to deal with that when it comes up. So as always, we have read your briefs and we're familiar with the case. Although you're free to use all 15 minutes, we will not hold it against you if you don't. And with that, I'll call the first case for this morning, which is Commonwealth versus Fagundes 18P1115. And it's defendant's appeal. So, well, maybe if you can say your name for the record for us.
Thank you. Good morning, Your Honor. Eduardo Masfer for the appellant Fernando Fagundes.
Good morning, Mr. Masfer. Wait, let's get the clock going. You go.
Thank you. May it please the court. The defendant did not receive a fair trial due to the significant and numerous errors regarding the admission of testimony that violates the dictates of the first complaint doctrine. It began when the court erroneous's finding that the two distinct conversations with two different levels of detail, which occurred on two separate days, constituted a single first complaint. It is well established that first complaint is the initial disclosure regardless of the level of detail that has been provided. The Commonwealth is not permitted to expand the doctrine to include successive disclosures to the same witness by one complainant. Commonwealth versus Arana makes it quite abundantly clear that as the complainant in that case made multiple disclosures to the same first complaint and then various other complainants that same night and that same day that were admitted in error. In Commonwealth versus Rebel.
Counsel, sorry to interrupt. What is the test for determining whether complaints are successive or part of a single complaint?
So the closest case I think on point that addresses that issue is Commonwealth versus Rebels. In Commonwealth versus Rebels, the court looked at the temporal proximity and the duration of the conversation. So in Rebels, it was a daughter and a mother. The mother had a difficulty getting the daughter to explain what happened and asked her to write a letter. The letter was written and a conversation occurred at the same time that the daughter wrote the letter and immediately after finishing the letter. And in that case, the court said that the letter was not a separate complaint, such as a letter written on one day and then discussed another day. Rather than the victim's first complaint to her mother constituted a single, tightly intertwined oral and written communication. So that is the sort of standing for that. The only other case we have is where there's a case where the complainant wrote a letter to her guidance counselor and then had a conversation with her guidance counselor, and the court held that those were two completely different conversations. The facts in this case reveal that the complainant indicated a single statement to her sister and another witness, Jasenia, saying simply, "Your uncle touched me inappropriately." That was the end of that conversation. She said she went to bed. The first complaint witness actually left the room and had a conversation with other people downstairs. And then the next morning, according to the complainant, the first complaint witness, her sister, confronted her and started to restart a conversation about this.
What do you
so
say?
we indicate that's the two different ones.
What do you say to your brother's argument that the Fernando touched me inappropriately statement wasn't an accusation of a sexual assault, and though didn't count as the first complaint?
So two things. First, the Commonwealth in its brief does not attempt to justify this as a single conversation in any way. They practically concede that it's two different conversations and now want to change it to indicate that the first statement is hearsay that was admitted because the Commonwealth, the defense attorney, and the court all viewed it as first complaint. The issue that that's not a complaint is completely foreclosed by Commonwealth versus Aviles. In Commonwealth versus Aviles, the victim said, and the only thing she said was, the defendant touched me. Touched me in and of itself was sufficient to justify a complaint. In this particular case, we have more than that. We have a 19-year-old woman saying, your uncle touched me inappropriately, where the allegation is an indecent assault and battery. Touched me inappropriately is practically the exact same thing as stating the offense. So I think the Commonwealth's argument is not accurate in terms of what occurred below, and it's trying to recast an issue which they've realized quite clearly they've lost here in front of the Court of Appeals. That error alone is reversible error.
So our case falls in between Revels and Arana. Would you agree with that? The facts are somewhere in between?
I don't think they are in between, Your Honor, because Revels deals with a written document, a letter, and there had been previous case law saying that if you submit a letter, that is the first complaint. You can't talk about the conversation as well. Here, we don't have a letter. Here, we don't have a simultaneous or intertwined conversation occurring during one time.
That's my point. That's my point, is that in Revels, it was two more or less simultaneous complaints, one oral, one written. In Arana, it seemed like there was a greater passage of time between the two complaints, the successive complaints. So what factors do we consider in determining whether a complaint is successive? A passage of time? Is it significant that they were asleep for a large portion of that time? And what do we look at?
I think there's a variety of factors the court can look at, but none that really apply here. You can envision a situation where a conversation is started and then interrupted. And so somehow the conversation is left unsaid or unfinished because perhaps as in Revels, the defendant walked into the room. And so they stopped the conversation so the defendant could leave, and then some other issues happened, and then they resumed the conversation. That's not what occurred here. There's no indication that somebody interrupted the conversation. There's no indication that the complainant wanted to say more. And I think really, if we have to set a standard, that would probably be it. The complainant doesn't say, he touched me inappropriately, and then seems to want to continue making a conversation or making further disclosures, and then is somehow prohibited or stopped from doing so. Rather, a decision is made. She's going to go to bed, Jasenia is going to go to bed, and the first complaint witness decides to leave the room and have a further conversation with someone else downstairs. So I don't think that there is, while there could be factors that would justify a more prolonged view of first complaint, they don't appear in this case.
Does it make a difference that it was the sister who initiated the conversation in the morning as opposed to the complainant?
I think one could envision a scenario where that really does make a difference. If the sister had, in this case, the complainant says, my sister started the conversation. So again, it seems like the sister is making inquiry to get further details, not that the complainant wants to disclose something. And insofar as the doctrine's trying to understand either why a person made a disclosure, exactly what that disclosure was, and the purpose for making it at that time, thus the first complaint, that seems to be absent when it's another individual making query the next day. Again, I think one could imagine a group of scenarios where the fact that someone else is prompting through the disclosure might still be permitted under first complaint, but they don't arise in the facts in this particular case.
So,
and that error, yes.
You know, what do we make of the fact then that defense counsel introduced a different first complaint? The roommate saying, you know, that it was groping, that the first complaint was, she told me my uncle or whatever his name, but the defendant groped me. Does that sort of alleviate the problem here?
It doesn't. It's simply inconsistent statements as to the first complaint. Again, we're still talking about the same initial complaint. That groped me versus touched me inappropriately is the first disclosure. I think there's a difference whether it's in a bedroom or in a foyer, but we're still talking about that those are the only limits of that disclosure. There was nothing further gone into. And the defense counsel has to do the best that she can with the rulings that are made by the court. The court had already let this in. The court proceeds to let in a series of other issues that were all going to be excluded under first complaint. For example, letting the complainant testify that she told her parents, letting her say that she had another conversation with her sister, letting her say that she told the police. Each one of those.
Counselor, doesn't the defense need the disclosure to the parents? Otherwise, the father questioning the defendant would make it seem like the father had seen groping. Isn't it better for the defense that the father's source of information when he questions the defendant is solely what his daughter told him?
It is not, Your Honor. That problem could have been alleviated quite simply. If the Commonwealth had simply asked the father, at some point, did you learn about the allegations? And the father answers, yes. That is the only foundation that's needed to justify that question. What the Commonwealth elicited instead was the complainant saying that she told her parents, the sister saying she told her parents, the sister saying she told her parents exactly what the the complainant told her. They introduced both the mother and the father to elicit this. The Commonwealth then goes on and then calls the police officer for the sole purpose of having him tell or testify as to her reaction while he's being told the allegations. That is also not appropriate under first complaint. And there are cases that have stated that they are not allowed to do that. The Commonwealth's excuse for some of these is either state of mind or to explain why something is occurring. But all of those arguments have been foreclosed by a variety of other cases, mostly that are cited in my brief, such as Arana and Ansejo, both which talk about that you can't simply say, well, to attack or to contradict the defendant's claim that the event did not occur, we get to talk about multiple times that we've told people. There has to be some sort of specific impeachment or specific bias to show. The one case that is cited, Aviles, is a case where the court permitted the introduction that the first complainant also told her grandmother because the defendant had already raised as a specific issue that the lie was being told to get into the grandmother's house. In other words, to start living with the grandmother. That made a very specific reason and logical way to expand slightly the first complaint doctrine. None of that occurred here. There was no specific reason to bring it up. The foundational question, as I already mentioned, could have been established a different way without violating the tenets of first complaint.
Why wasn't the officer's testimony about the victim's demeanor admissible to refute the claim of fabrication?
So the Supreme Judicial Court has said that that can always be the case. We can always talk about fabrication, and therefore every single time or any reaction the individual has when telling the complaint to anybody would be admissible. That would eliminate first complaint doctrine.
I'm talking just the testimony limited to the officer's observations of her demeanor. Wasn't that testimony admissible under Arana?
It is not. Under Arana, you can introduce testimony of people saying, I observed the victim's demeanor in the immediate aftermath of the event itself. So for example, if somebody had said, at the party, she seemed upset. The next morning, she seemed very upset. At the party, she was crying or got isolated, something that relates back. But here, we're talking about her demeanor when she talks to the police officer about the events in question. So it's really just first complaint all over again. They're going to introduce that she told the officer what occurred, which is not permitted. And the fact that the officer then gets to talk about how she observes or how the officer observes her while she retells the complaint again is also not permitted. There is no case that stands for that proposition. What the Commonwealth does is take one ruling of law that sometimes you can talk about a person's demeanor and tries to use that to backdoor in first complaint again with the police officer. Those errors in conjunction about first complaint alone are sufficient to justify reversal of this trial. It affected the way cross-examination was done. It affected the way that the defendant's strategy proceeded, because now the defendant had to get into a variety of other issues that they would not otherwise have raised if the first complaint doctrine had been adhered to in a proper fashion. The next issue that we raised for the court is the issue about the witness that the defendant called and the Commonwealth's attempt to introduce that witness's opinion as to whether or not the allegations are true. The Commonwealth's brief rewrites history in terms of the order of things that occurred. But what occurred at the trial, as the transcript demonstrates, is that the defendant attempted to introduce the complainant's reputation in the community for truthfulness. That was denied by the court. The prosecution on cross-examination then introduces the text message to say, isn't it true, basically, that you told her that she doesn't lie? In other words, that witness's personal opinion that the complainant is either truthful or was being truthful in that moment. That is not permitted. There is no exception that allows one witness to testify as to the truthfulness or untruthfulness of the other. After the court lets that in, the judge, sua sponte, says that now the defense can reattempt to introduce the complainant's history of
if it had been, if it had been the other way around, if the defense had initially been allowed to put in the reputation for truthfulness, would the cross-examination with the text be proper?
No, because you still have the same problem. It's not her individual opinion as to somebody's truthfulness is not relevant. It is never relevant as to if one particular person says that they think that they believe or disbelieve another witness's testimony. So the reputation evidence can be combated with other reputation evidence, but not with a direct evidence of one person's personal opinion. And that's what the Commonwealth attempted to do, or this is what the Commonwealth did here. They reversed the order. But even if the order had been proper as they want it to be, that wouldn't have solved the problem. And all of this
what if they said, so you say that's the reputation in the community. You don't share that view. They couldn't say that?
They might have been able to, but that's not the case that occurred here. I think that's beyond the record that the court has before as to what occurred in this trial. That error alone is also sufficient to justify a new trial. But then in closing argument, the Commonwealth takes all of the errors we just talked about and re-brought them into the closing. They talked about corroboration, and the corroboration that they cited to and linked to in closing was all of the first complaint evidence that we're suggesting the court was not properly admitted. So they did rely upon it. In a case of dueling credibility, these issues become extremely important as to whether or not there is corroboration, whether another person thinks that person is being truthful or not, all become crucial points to the case. And so I don't want to think that we've waived any particular issue, but with that, if there's no further questions, I will rest.
No, you don't waive it by not raising an oral argument. No problem. Thank you very much. Are there any other questions before we hear from the ADA? Okay. So we're going to put you on mute. And Mr. Tretyakov, you're up.
Good morning, Your Honor. May it please the court. My name is Konstantin Tretyakov. I'm an assistant district attorney for the Middlesex County District Attorney's Office. I represent the Commonwealth. I would like to start with the first complaint doctrine issue that my brother is raising in his brief. I want to start with emphasizing that the standard of review here is first abuse of discretion, and then if the court finds that there was an error under the abuse of discretion standard, it's prejudicial error because many of those issues were preserved. As far as the abuse of discretion is concerned, of course, the court is not reviewing the rulings of the judge de novo. Rather, the court is asking whether or not the decision made by the judge was so unreasonable that it fell outside the range of reasonable alternatives here. So with that in mind, I want to turn to the testimony of the victim and her sister about the conversation that occurred between them in the morning after the offense. And responding to Judge Shin's question, she asked earlier about what standard the court should be guided by in deciding that issue. I think the case law, King, Aviles, Dale, and their progeny makes quite clear that the standard is that the first complaint doctrine is not a shield to foreclose the jury from getting as complete an account as possible with respect to the accusations that arose. In this case, the victim told her sister, who was quite intoxicated on the night of the offense, that the defendant touched me inappropriately. That is not in and of itself indicative of a sexual assault. If I'm sitting here and someone comes from the back, gently rubs my shoulders, and then runs away, that's an inappropriate touching, but there is nothing indecent about it. So the judge made a decision to which the defendant did not object at the motion in limine stage, that the part of the conversation where the victim actually describes to the sister the sexual assault that she endured from the defendant would also be admissible. Had that not been the case, the only two things that the jury would have heard would be the defendant touched me inappropriately, said by the victim and the sister, and then the victim's ex-best friend, the defendant's niece, testifying, the victim told me that the defendant groped me.
So how do you distinguish, counsel, how do you distinguish Aviles? I thought that the first complaint there was very similar to something along the lines of touched me inappropriately.
Your Honor, again, the case law the case law makes clear that the essential feature of the complaint is the report of sexual assault. What happened in Aviles is that the victim told, I believe, her mother that the defendant touched me, but that was in the context of the victim crying and refusing to go to the bedroom. When the jury was presented with that evidence, I think it provided quite a clear picture for the jury that if you have a child who is crying, who is refusing to go to the bedroom, and who is telling her mother, the defendant touched me, that was in and of itself indicative of sexual assault. That was not the case here, especially after the defendant elicited from the defendant's niece the testimony that she, quote unquote, very nonchalantly told me that Fernando might have groped me. So in this case, Your Honor, and again, circling back to the standard of review, it's abuse of discretion. It's not de novo. The question before the court really is whether the judge's decision to admit the second portion of that conversation was so manifestly unreasonable that it fell outside the range of reasonable alternatives. And I would respectfully submit to the court that it did not. With respect to...
So do you concede that if the touch me inappropriately was the first complaint, then the conversation the morning after qualifies as a successive complaint and not part of the same complaint?
Your Honor, I would say that it's the part of the same conversation because the testimony established, I think, that the sister, who was the designated first complaint witness, and by the way, to whose testimony and only to whose testimony the Commonwealth relied in its referred to in its opening and closing argument as a first complaint testimony, the sister was quite intoxicated during the night of the offense. So I think on these facts, and as I think you emphasized, or Judge Massing emphasized, that the time that elapsed between the first and the second part of the conversation was basically they were sleeping. And then the sister in the morning, in continuing of the conversation that started between the two sisters, she confronted the victim and asked her basically, what did you mean by that? And then the victim describes what happened to the sister. Again, on those facts, I would submit to the court, I don't think it was an abuse of discretion for a judge. It was not manifestly unreasonable for the judge to say that both parts come in because, again, according to King and Aviles and Dale, it's important to provide the jury with as complete picture as possible as with respect to how the account of the first, how the complaint of sexual assault arose. With respect to the testimony that the victim, my brother respectfully misrepresents a little bit in the brief about the testimony of what the victim described to her parents. All the victim said in that respect, it's on page 86 of the trial transcript. They called me after the sister had told them what had happened, so I spoke to them on the phone. So the victim's testimony was essentially limited to the fact that, yes, I spoke on the phone to my parents. She did not relay any specific details of that conversation between her and her parents.
Wait,
and
Counselor, I'm looking at it now. I decide to report what had happened to me.
Pardon me, Your Honor?
I decided to report what had happened to me. Isn't that saying I told them about the sexual assault?
Which page of the trial transcript is Your
I'm
Honor?
on page 86, the one you told us to look at. I'm looking at line 15.
If I could have a moment, Your Honor. Your Honor, that was referring to the report to the police, not to the parents. And that was the victim testified, you decided to report what had happened to me, and then she says, the Commonwealth asked her, I eventually went to spoke to the Ashby Police Department. The victim said yes. And
that's the line after.
Yes.
You eventually spoke to your parents, is that correct? Well, actually, I spoke to them. They called me after my sister told me what happened. So I spoke to them on the phone, objection overruled. Then you eventually went to school, yes. And did you ever back to your parents' house at all? Yes, I decided to report what had happened to me after the weekend. And I went back home for a week. And
Correct.
then you eventually went and spoke to the Ashby Police Department.
Yes, so I think that was indicative of the fact that the victim was saying, when she's saying report what had happened to me, I think it strongly suggests that she was talking about reporting to the police. If the court reads this testimony differently, by my apologies, but I think it's a reasonable interpretation to say that the victim said she decided to report to it, so she went back home for a week, and then the prosecutor asked for a follow-up question, and did you go to the police? She says yes, and that was not objected to, which goes to the next issue of the first complaint that my brother is raising on appeal with respect to the demeanor of the police department. There is a case that actually governs that specific issue. It's Commonwealth against Starkweather. That's 79 Massachusetts Appeals Court. The relevant part of the decision is on pages 800 and 801, where the appeals court says that the state of mind of the victim is absolutely relevant in sexual abuse cases, and the testimony about the demeanor of the victim to the police officers is admissible in that respect. In this case, the jurors learned that the victim went to the police without objection from the defendant. After that, on cross-examination, defense counsel repeatedly questioned her about her visit to the police 4 days after the offense. You didn't go to them on Friday, you didn't go to them on Saturday, you didn't go to them on Sunday, you didn't go to them on Monday. It was only Tuesday that you went to the police. The defense counsel also extensively questioned the victim along the line of fabrication evidence. Did you see that the defendant and his wife were spoiling their niece with gifts? Did you hire a civil lawyer? Did you receive a letter with promises from the Massachusetts, from the DA's office? Did you notice several things about the socioeconomic status of the defendant? Does he have a nice car? Does he live in a nice house? Were they serving champagne? And in the end, the defense counsel also said to the jury in her closing argument, the witness was very emotional on the stand before you yesterday, but she was not emotional on the night of the offense. That very strongly suggests that one of the lines of the defense was fabrication theory, that the victim just concocted the accusation against the defendant. And
so why is her demeanor to the police officer 4 days later relative to that? It's not her demeanor after the crime, it's her demeanor 4 days later.
It's her demeanor on her first encounter with the police officer, and it was admissible to refute the defendant's theory, which was extensively, again, introduced before the jury on cross-examination of the victim about the delay of the reporting to the police. It was her state of mind about the crime. And I think Commonwealth against Starkweather supports that proposition. I also wanted to emphasize, Your Honor, that even assuming, for the sake of argument, which the Commonwealth does not concede, even assuming that there was some errors in admitting some of the portions of the first complaint evidence here, as I said at the beginning, the court really reviews for prejudicial error, reviewing all the evidence introduced at trial as a whole, including the evidence of the defendant. And the defendant's evidence in this case, Your Honor, supplied the jury with independent basis to convict him of assault and battery, of indecent assault and battery of the victim. All four elements were there. The defendant admitted on testimony that he touched the breast, that his fingers could have brushed on the breasts of the victim, the sides of her breasts, as he was doing the massage. That the age of the victim was never a live issue at trial. Everybody agreed that she was over 14. The touching was intentional because, as the defendant himself said, it was all hard rubbing and generating heat. And as he also said on page 214 of volume 2, the victim only consented to massage of the back, whereas he went to the front following what he called the dorsi muscle, I believe, that goes from the back to the front of the torso and all the way into the pelvic area. The defendant was also able to tell the jury that the victim was wearing tight jeans and she was wearing a belt. So when my brother in his brief characterizes this case as a battle of credibility between the victim and the defendant, respectfully, Your Honor, I would disagree. Because in this case, the defendant's testimony not only significantly corroborated the account provided by the victim, it also supplied the jury with the basis to convict him because all the four elements were there.
Counsel, you seem to have made massages illegal. I mean, he described a consensual massage where, yes, he may have touched her bra, but was only rubbing her back, and she hadn't specifically asked for the massage. I mean, if your theory is right, are massages illegal in Massachusetts?
No, Your Honor, the massages are not illegal in Massachusetts, but the Commonwealth theory of the case was assault and battery, indecent assault and battery on a person over 14, which was hand on the breast, hand on vagina, and hand in the mouth. There was no specific unanimity instruction requested by the defendant. There was no particularized verdict, which can be found on page 15 of the record appendix. And then the defendant says on the testimony, the prosecutor is asking him, that's when you went down the side of her to the right and left of her breasts, and then onto the abdomen, to the side here, yes. And then, and previously on direct examination, he says, my fingers might have brushed on the sides of the breasts of the victim. And again, he is also saying that he was following the dorsi muscle that goes all the way into the pelvic area. And he says that the victim was wearing tight jeans with the belt. And he also characterized the relationship between him and the victim and her family as, quote, very friendly, very frisky. So
can I just a little bit of time left. Could you address the text, where she says that you don't lie?
Correct. So just to clarify, when the Commonwealth attempted to admit that text on cross-examination, it was not admitted because the testifying witness, the defendant's niece, refused to authenticate it. So it was admitted only for identification purposes. The jurors did not see that text at that time. After that, on redirect examination, defense counsel elicited from the defendant's niece over the Commonwealth's objection that the victim has the propensity to exaggerate things and has a reputation of an opinionated person in the community. Only after that was admitted on redirect examination of the victim did the Commonwealth, in the end of the trial, after the defendant testified, called the victim as a rebuttal witness who identified the text message, "You don't lie, I know you don't lie," and that message was authenticated and was admitted as an exhibit to the jury.
So is that relevant to her reputation in the community for truth-telling?
Your Honor, it's an inconsistent statement with what the defendant's niece had testified to by that time, so it was admissible on that basis. I see that my time has expired, Your Honor. Unless the court has further questions, I would rest on my brief.
Any further questions? So I just want to say to both of you, excellent argument, both of you. And you know, we see you on Zoom, even when you're not arguing, and sometimes counsel acts inappropriately, but you guys kept it very together, and I really appreciate the demeanor of both of you during this. So thank you very much. We'll take this under advisement, and I hope you are both well and stay well.
Thank you very much, Your Honor.
All right, we are live and on the record.
So good morning and welcome to the Massachusetts Appeals Court oral argument session for May 15, 2020. I'm Greg Massing, and with me today is Justice Shin and Justice Ditkoff. We're your panel for today. As you know, this argument is being done on Zoom and being live streamed on the Appeals Court YouTube channel. Nonetheless, we'll follow the same rules as usual, 15 minutes per side, no rebuttal. Only one of you will speak at a time. The other one will be muted during the other's presentation. But remember, we can still see you. So no inappropriate motions or excessive nodding or whatever. Once we get going, the clerk will display a countdown clock, and this proceeding will be recorded. So it will be, everything you say, of course, will be heard by those watching and will be archived as usual. If we have any technical problem, we might have to stop the session and maybe even put you in the waiting room. Hopefully that won't happen. As always, we have read your briefs and we're familiar with the case, so you can get right into your arguments. Although you're free to use all 15 minutes, we won't hold it against you if you finish early. So with that, I'm going to call the case, the second case for today, which is Commonwealth versus Rooney, 18P 1175. Attorney Lindmark.
Yes, good morning. Good morning, Your Honors. I'm Attorney Lindmark. I'm here today, as you know, arguing on behalf of Mr. Rooney. This is a case alleging possession and dissemination of child pornography. It's my hope to focus first on issue 1, touch upon issues 2 and 3, and rest on my brief as to issue 4. As an initial matter, I need to address the issue of what evidence actually was introduced at the time of trial. Unfortunately, in my brief, I miscited the presentation of evidence somewhat. I'm hoping now to
Now, wait a
rectify
second.
that. It's my understanding that actually, can you hear me now?
Yes, we can. Yeah, we had a little glitch there, but it's okay.
Oh, okay. So it's my understanding that actually there were 4 photographs of child pornography presented. There were not the videos at the last minute. The judge did refuse to admit those into evidence. That was my error. And I apologize for any confusion that might have caused. In any case, it's our position today that even considering the revised list of evidence, our argument remains the same. The listed items submitted to the jury were unnecessary. They were overwhelming and due to their egregious nature, excuse me, and the risk of prejudice to Mr. Rooney was very great, unreasonably so. It caused an unfair trial.
So can I just clarify the screen? There's the Exhibit 57, which is a screenshot of a man and a young girl from a video. That in itself wasn't pornographic, right? That was just showing who the characters were.
Yes, correct.
Okay, and then 58, yes, and so the video thumbnail Exhibit 59 was 2 photographs. Is that your understanding?
That is my understanding as well, Judge. It was somewhat, it was a very detailed case, as you know, right. And it was a little bit confusing.
So those three are graphic.
Right. And we're also objecting to, there were several very detailed descriptions of videos presented by police witnesses at trial. And it's our position that those descriptions also were unnecessary. None of this was necessary. Child pornography was not the contested issue at this trial. That had been stipulated to. And there were stipulations that the evidence involved had new children under the age of 18, that this was pornography. What was at issue here was Mr. Rooney's exclusive possession and control of the computer and the evidence that was seized from it.
Why didn't the Commonwealth need to show that the child porn found on the Asus laptop was different than the anime being watched by the stepson?
And the question in regard to that, I'm sorry?
Why didn't they need to give some description of the child pornography to show that it was different in kind and nature than what the stepson was watching on the HP laptop?
Well, it's my understanding of the case that he never was charged with possession of child pornography, although we feel he should have been. And that evidence would have been irrelevant to the Commonwealth's burden of proof showing Mr. Rooney was in possession of what was found on his laptop. I'm not sure if that answers your question.
I mean, I guess what I'm wondering is, where it's plain that the stepson is watching something when the police come in, doesn't the Commonwealth need to show that the images that they're charging are very different from those images that the stepson was watching when the police came, to suggest that it's different in kind and therefore not his?
Well, again, I'm not sure why they would have to do that, Your Honor. We're dealing with charges, unfortunately, only brought against Mr. Rooney. He wasn't charged with possession of those images on his son's laptop. Therefore, that would not, in my opinion, have been relevant to the case against him.
How about the fact that the Commonwealth had to prove your client's knowledge, and they had to, and one of their arguments was that it was obvious to anybody downloading this stuff that they were, it wasn't an accident, but this was pornography?
Well, it's our position that he did have access to his computer, obviously. However, there's conflicting testimony, and in essence, really, his stepson admitted to first the police, then investigators, and then at trial that he in fact possessed much of this pornography. He viewed it on all of the computers in the home, including his own, and he felt that he possibly might have failed to delete it from the computer when otherwise he would have. So the question becomes, I believe, whether the judge abused his discretion in allowing into evidence these photographs and the trial testimony, which we're saying was highly prejudicial, creating reversible error. It's our position that despite his best intentions, he did abuse his discretion. As he himself said at trial, that's what inflammatory evidence does. It tends to inflame the passions of the jury, and they let their heart and their stomach take over where their brain should be. And it's our position that's exactly what happened at this trial, and it created reversible error as a violation of Mr. Rooney's constitutional rights. Then I guess I'll move on to issue 2, the required finding of not guilty. Again, it's our position. The wrong person was charged in this case. There was conflicting evidence and testimony. And as to Mr. Rooney, the Commonwealth failed to meet its burden of proof. The evidence establishes there were several computers involved here. All 3 residents had equally unfettered access to those computers. There were thumbnails seized from Langston Coleman, the stepson's bedroom. He was inexplicably, he was not charged. There was cartoon.
The only charges actually though came out of stuff that was on the computer on the defendant's bed, right?
Correct. And in our analysis,
I mean, and so we have to look at the evidence in the light most favorable to the Commonwealth, and it seems like there's substantial evidence that the computer on the defendant's bed with the pornography and his golf tees and his names and passwords belonged to him. Perhaps the stepson had access, but joint possession doesn't defeat the defendant's possession.
No, and we would agree that all 3 adults, all 3 being adults, had access to all of the computers in the house. And the fact that he did not have exclusive control and possession of this computer works in his favor. And the argument that he really did not know the depths of what his stepson was involved in, and should not be held liable for his actions. On the issue of Langston Coleman, I mean, the evidence is clear that he was viewing cartoon pornography when the police entered. He had access to all computers in the home. The mother's testimony that he had been specifically reprimanded in the past for this. He had mental health issues, a history of deceit, and his very own testimony. And we would suggest to the court that this shows that Mr. Rooney did not have exclusive control over this computer and should not be held liable for what was on it.
But why does it matter if he doesn't have exclusive control?
Because it's just as likely that Langston Coleman, this pornography belonged to Langston Coleman as it did to him. And as a result, we feel the Commonwealth failed to meet its burden of proof.
Are you suggesting that we have to discredit the stepson's testimony that he never used that laptop? And that he didn't?
Well, there is testimony from his mother that in fact he did. And I think that his own testimony made it clear that he was very much engaged in viewing child pornography a great deal of the time, and in fact making statements such as that he particularly liked to watch Asians. It's just all very troubling.
I mean, he may have, but if he was only doing it on the HP laptop, it isn't exculpatory to your client at all. So do we have to disbelieve, are you suggesting that we have to disbelieve his testimony that he didn't use that laptop?
I would suggest that the evidence in total suggests otherwise, Your Honor. And some, as to that issue, we just, our position is the judge made a clear error of judgment. He was well-intentioned, but he made an error nonetheless. And third, just moving on to the closing argument, there were various issues with the prosecutor's closing argument, and she clearly was trying, in our opinion, trying to inflame the passions of the jury. She engaged in repeated demonizations of Mr. Rooney. She was attacking the evidence over and over and over again as disgusting, and then in the next breath, mentioning Mr. Rooney's name, in essence, again, demonizing him as a person and his character. She attacked her own witness, Andrea Newsom, saying the jury can't believe her, and shame on her for talking about her son, or even thinking that he might have been involved. Improper vouching. And some, we feel that
why is that improper vouching? I mean, are you allowed to argue from the evidence whether or not to believe a witness?
Well, this was her own witness is one problem, and she shouldn't. I think the case law establishes that that attorneys in their closing arguments can't personally attack witnesses. That's inappropriate and improper. So again, our argument here is that in sum total, her closing argument created a substantial risk of miscarriage of justice. It was improper and it was inflammatory. And then I would rest on issue 4.
Can I just ask you one question about issue 4,
Yes.
which is this is being raised for the first time on appeal, right?
Yes.
Okay.
And I did discuss this with my supervisor, and that was an error.
I'm sorry?
I did discuss the whole issue of that, and this is the first time that it was raised on appeal.
Okay. Thank you.
Thank you.
I see no further questions. So if you want to rest on your brief on that last
Yes.
issue, so I think
Yes.
we're good. Thank you very much for your argument, and thank you for clarifying the error in your brief. That was
That was a mistake. Yes.
thank you. ADA Jordan.
Good morning, may it please the court. It's R.C. Jordan on behalf of the Commonwealth. I would like to point out an error actually in my brief. On page 47, I refer to the torrent files found on the ASUS laptop as being 450. There's actually 50 torrent files found on that laptop. The 450 is actually a reference to the torrent searches found on the Hewlett Packard that was found next to the ASUS on the defendant's laptop. So I apologize. Math isn't my strong point.
How strong is your understanding of dissemination and sharing of videos? Because I'd like you to explain how that file sharing works and how you know that the defendant intended to share the file.
Absolutely. I think I do cite Molina in my brief, and I think that case is very educational, how it lays out how the expert testified and then how the court relied on that testimony to find sufficient evidence for dissemination. The way it basically works is that a user needs to go out and seek the share, this peer-to-peer file application, just as we would download an app or Zoom on our computer. So it's something that has to be an affirmative action done. The whole point of these files is to share files. That's both to take and get. The inherent nature of these programs is to allow for that kind of sharing. So basically, if you're not going to share what you have, it prevents you from obtaining files from others. And the way it works is that if I have, in this case was BitTorrent, and this was all explained to the jury by one of the detectives. I would use the application, search for a torrent file, and then the torrent file is actually a file that contains information to then go out and get bits and pieces of that file from all the other folks that have that same file sharing device. So it basically allows for a quick download of a file by basically making it a group effort. And then in this case, the way it works for the for the undercover, specifically when they use these kind of files to see who's sharing child pornography. Their programs allow, so they're only getting those bits and pieces from one user. So that means in this case, when Lieutenant Hill sought out on these share file programs for one person in Massachusetts, he was able to isolate the files that he eventually did download, specifically to the IP address that traced back to the defendant. So in essence, the way the share filing works, I get a torrent file, I look up, I think the example at trial was, it might've been Titanic. I want Titanic, I go out there, everyone tell me what you got. And then as I'm requesting it, I'm downloading it, but simultaneously, if anybody else is also looking for Titanic, they're actually getting bits and pieces from my file simultaneously. Does that help?
That's helpful, thank you.
And so
what's the significance of the default position? Was that explained at trial?
yes, that was explained at trial, because these are, the whole essence of them is this peer-to-peer sharing. And when you download the program, the default is to allow for that sharing. And as I already mentioned, it only works if you can only get if you allow people to receive from yours. So the default setting is basically allows for the program to work. So if you reset the default setting to something else, the program wouldn't work. There would be no point in actually having that program. So the fact that he didn't undefault it really isn't meaningful, only because it wouldn't be able to be used if it was otherwise set. Does that answer your question?
What's the point of having the setting in the first place?
I don't know how far that goes. I don't know if the only thing I can guess or postulate is that the way these file sharing works is that it downloads and shares even if you're away from your computer. So I think if you started to download something and you wanted it to stop in the mid of that download, you could probably put on the undefault and stop that from automatically happening. But I can't really see another reason for it. I apologize, I don't know, I'm not technically savvy, but all the evidence in this case was that not only was it on that setting, but it was used. The only way that the defendant would be able to get the 50 torrent files on his computer was that if it was set to that file sharing ability. And not only that, but there was tons of searches that also suggested those applications were being used, not only when Lieutenant Hill was actually participating in the downloading of them from the defendant's computer.
So if I understand it correctly, it's not so much that the defendant was like intentionally handing out, or showing people this pornography, but he was passively allowing it to be taken from him.
Yes, but that is the passive nature of it. But I would suggest there's an affirmative action by putting that application on your computer, setting it up to be used, and then actively searching for torrent files yourself necessitates this dissemination of those. So as soon as you start looking for Titanic, that user is allowing other folks to also get what they have. It's inherent in the program. And the defendant had, I think, 4 separate kind of these peer-to-peer applications on his computer. So even if we say, oh, it's passive and you didn't know, I would suggest that the fact that there was 4 of them on his computer, there can be an inference that he was actively using them and purposefully putting them on his computer and the evidence suggests that based on his searches, the autofill and the other things that actually the thumbnails were found on his computer, that indeed he was using them to get child pornography.
And also, I mean, presumably, if you cite Molina says that this is sufficient to prove the intent to distress.
Yes. So Molina talks specifically about the whole nature of these peer-to-peer filings, and that due to the fact that that is the nature of them, the possession of those peer-to-peer applications on the computer in conjunction with evidence of their use would be sufficient to show dissemination. And then just to parlay that into the possession, that case also says, if you have these files, if you have files through these applications to disseminate, then you must have possessed them initially for their dissemination. So if there's evidence sufficient for dissemination, there's evidence sufficient for possession.
Could you address the was it the 3 or 4 graphic photos that came in and why that was not an abuse of discretion?
Sure. I do want to clarify, there was actually 4 images that would be sufficient for child pornography. And that would be, it would be Exhibit 58, which was an image that Lieutenant Hill testified that he downloaded on the April 14th date. And then I think some of the confusion is, and then Exhibit 59 is actually 4 different thumbnails. And the photos of those, it's 2 through 4, which are the child pornography. And in 59, photo 1 is actually a picture of a child in a white onesie, which is duplicative of Exhibit 57. And that image is actually the screenshot / thumbnail from the video that Lieutenant Hill downloaded on March 4th. And then there's one photo, I think it's photo 4 or 4, I think in 59, that is shows an image that I would suggest is consistent with the video that Lieutenant Hill downloaded on March 6th. So I think in this case, there was a lot of litigation about what was appropriate to show to the jury. I think at the end of the day, what was actually shown was only a small portion of what was actually found on his computer. The case here was basically showing that the defendant would have to know that this was child porn on his computer, that any innocuous use of the computer, he would have to encounter these very obscene, even the file names were extremely descriptive. And that really went to his knowledge, even if he was not the one that downloaded them, that he would knowingly be in possession just through use of, there was evidence of his work, of his bills, of home improvement, of his leisure activities. So I do think that goes directly to one of the elements the Commonwealth had to prove. This is not the type of case where the judge didn't take time to look at what exactly was going on and what was being before the jury. The descriptions were also necessary, as the Commonwealth did. The stipulation doesn't suffice for the Commonwealth to meet its burden, but the descriptions were necessary, again, to show how obscene these things were, and that he would have to see them if he was partaking in any of the other activities on his computer.
And I believe you filed a motion to transmit the exhibits, is that right?
Yes, I did. I think in this case, I think if there is this argument about what kind of images were submitted to the jury, I think it would help for the court to look at them. There's also many documents of big Excel spreadsheets that documented the types of files that were also downloaded. I did have a chance to look through them, and what it does illustrate that I don't think necessarily comes out in the transcript is that there will be a torrent file search for pornography, and then the next search would be I don't know, some home improvement search, then more child pornography, and then another search for some, for a boiler replacement. It's just very much woven. Child pornography is very much woven through all the forensic evidence that was found on the defendant's computer. I don't know if the court is interested in me addressing any of the issues then closing arguments.
Yeah, how about saying disgusting 4 times?
I think in this case, I think the use of the word disgusting, I think goes to the fact, again, how obscene these images were, and that it would be I think, incredulous to suggest that if these things were on the defendant's computer that he didn't see them. I think this goes in the line of hyperbole, and it's apparent that the prosecutor is arguing that, of course, child pornography is offensive as well. And I think in this case, even if it were to be ruled improper, the evidence of the defendant's guilt was so overwhelming that this kind of statement wouldn't necessitate a new trial.
I assume you think the images were disgusting.
I'm sorry?
I assume you think the images were disgusting. You're not walking that back.
No, I think that's fair. Having seen them, I think disgusting would be an accurate representation of what they were. I think Judge Muse really discussed them in an accurate way that, although they're if you will, inflammatory to the subject matter, that alone doesn't necessitate not having them admitted as evidence. Most evidence that's admitted against a defendant is prejudicial, and the fact that we're dealing with child pornography doesn't necessarily mean that it's not admissible. If it could necessarily, I don't think the word inflame, the way we use it legally, in how we talk about inflammatory nature such that it results in prejudice, equates to disgusting in this case.
You may not know this, but is it the case that the trial prosecutor didn't know the stepson had admitted to watching child pornography to the investigator before the cross?
That is correct. Prior to the cross-examination, the only evidence regarding the Coleman and child pornography was that when Detective Sullivan speaks to him at the house, he says, if there's any child pornography on my computer, it was inadvertent and I would have deleted it right away. And then during cross-examination, Coleman says, no, I don't watch child pornography. And then it's elicited that on an unknown date, in the presence of the defense attorney, an investigator, the defendant, and his mother, that he says, yes, I've watched child pornography. So his testimony was very inconsistent. And I think any of the arguments that the prosecutor makes in closing highlights the inconsistency and basically the incredible nature of what he was saying to protect his stepfather. I see my time's expired.
I don't see any body language indicating further questions. So thank you both. We'll take the case under advisement and have a good weekend and stay safe and stay well. Today is the rest of the panel, Judge Shin and Judge Ditkoff. As you know, we're doing this argument on Zoom and it's being live streamed on the Appeals Court YouTube channel. But nonetheless, we'll follow the same rules as in the courtroom. Each side gets 15 minutes, no rebuttal. We'll ask you questions. One difference is that when you are not speaking, you will be muted. However, we will still be able to see you, so please avoid any gesticulating or inappropriate conduct while the other person is talking. Once you get going, the clerk will display a countdown clock, and this proceeding is being recorded, so it will be archived as we do other oral arguments. We are experiencing a little bit of technical problems today in that the video is freezing up, but the audio seems to be fine. So as long as we can still hear you, we'll keep going. If we have to, if it gets worse, we might have to stop and reconfigure somehow, but hopefully that won't happen. So as always, we've read your briefs. You have 15 minutes. Feel free to use it, but feel free not to use the whole time. And with that, I'll call the case, which is Commonwealth versus Tassie, 18P725. And Attorney Shea, you have the floor.
Good morning, Your Honors. Richard Shea, representing the defendant appellant, Dominic Tassie. I'd like to address the first two issues in my brief this morning. First, that there was evidence to support giving a manslaughter instruction, involuntary manslaughter instruction, and that it was error not to do so, which prejudiced the defendant. And secondly, that there was insufficient evidence under Lattimore to convict him as a joint venture in witness intimidation. The one principle I'd like to highlight at the beginning is that the jury is entitled to believe a witness in whole or in part. And in this case, there were two eyewitnesses who implicated my client. I would suggest that the jury could have completely discounted the testimony of Clarence Bates, who observed the aftermath of the shooting from the third floor window of the house next to the driveway where it occurred. He contradicted the gentleman, Mr. Fuller, who was seated in the passenger seat of the car in significant detail. Importantly, where my client was located in relation to the car or the driveway during this incident.
Counselor, I know you don't agree with this, but if your client specifically withdrew his request for the lesser included instruction, is it error for a judge to honor a defendant's request that a lesser included instruction not be given?
Yes, because the judge had already made up his mind, and the effect of the attorney withdrawing the request was a nullity, as I argued, that it had no, if he had said nothing at that point, the attorney, he would have preserved the issue for appeal. The fact that he went on and for some reason said, all right, I'm convinced by what you say, Judge, I withdraw the instruction. It did not have any impact on the trial. The state of mind of Tassie was crucial, and it wouldn't have been affected anyway, whether they're anticipating instruction.
I get that's your argument, that his withdrawal wasn't really a withdrawal. But if we see it as an actual withdrawal, an actual request that it not be instructed, what do we do? Is that just not error, or do we review it for something else?
Well, if you disagree with me, then it's substantial risk of a miscarriage of justice, how it would be reviewed. I'm not raising ineffective assistance of counsel at this point, at least. I believe that the substantial risk of a miscarriage of justice standard sufficiently requires reversal. With respect to the attorney's actions, the test under substantial risk is whether there is any, on the face of the record, whether there's any valid tactical reason for the attorney to have made the error. And in this case, there couldn't have been, because he pushed for this. He wanted it on January 9th. The judge said he would give it. He filed a motion on January 10th for the instruction. The judge said, wait, I thought about this overnight. And for the following legally incorrect reasons, this is not, manslaughter is not a lesser included offense of murder, and he was indicted for murder as a joint venturer. So this manslaughter instruction is anomalous. And counsel argued with him a bit, and then he backed down. He said, well, I guess it would confuse the jury, so I'll withdraw it. That's not a valid tactical reason, because he was being persuaded by the error, which the judge, the ruling of the judge, which was error. The most he could have done would be, and I think it would be too much to expect, this trial is going on, to go back to his Westlaw and try to figure out whether manslaughter in these circumstances is a lesser included offense. So my point is that he was, there was no valid tactical reason. He was going for it. He wasn't looking for an all or nothing verdict. And all what the transcript shows us is that counsel got tripped up by the judge making this legal error.
So on the merits, can I just ask you on the merits of the instruction? So if the request is before, we look at the evidence in the light most favorable to your client. What is the evidence that would substantiate a voluntary manslaughter instruction? What is the evidence that he didn't share the intent to kill?
The evidence is that he drove into the driveway with the shooter. The testimony that he did not try to block that car. The two of them went into the house up to the second floor. They were heard by Yvonne Pierre through a door arguing, and the shooter was angry and referred to the victim as that effing N-word. Tassie was arguing with him, which could be inferred that he did not agree with whatever Almanor, the shooter, was going to do. They went outside, according to Fuller, and Almanor went to the car, the driver's side of the car. Tassie went back to the end of the driveway, he said, or at the end of his car. It wasn't really clear whether it was the end of the driveway or the end of the car. And he added for the first time that that Tassie was acting as a lookout. That could be completely discounted because, as counsel brought out in closing argument, all of the inconsistencies with the prior statements, it was not, that was something that was added on. So what he did was, Almanor is arguing, the gun is down. He's arguing with the driver. And Tassie walks up and says, I don't know what's taking you so much time. I would have popped his ass by now. And then he turns around and he walks back down the driveway. 5 or 6 seconds elapse. The victim then looks up at the shooter with a smirk on his face, according to Fuller, the passenger. And at that point, Almanor said, "Oh, you think this is funny?" He raised the gun and pulled the trigger. So the only culpable, the jury could credit the only culpable evidence being this statement of impatience, and it could fit within the third prong of malice, or it could fit within wanton and reckless conduct under manslaughter. And I point to the Michelle Carter case, where I think it's really on point. It was verbal urging to do something can be involuntary manslaughter. And the Carter case cites the Atencio older case, which was a Russian roulette game in which an individual shot himself. And the court said that creating the atmosphere in which this occurred, participating in the atmosphere, was sufficient for manslaughter. So it's up to the jury how they're going to view this evidence, whether they're going to view it as an intent to kill, which maybe they could if they believe Bates. If they believe Fuller in significant part, they would find that the defendant was only making an impatient, wanton and reckless urging, come on, get it over with. And that it's up to the jury to decide, is that malice, or is it is that third prong of malice, or is that wanton and reckless conduct?
So-
And the jury was deprived of the opportunity to make that very subtle distinction. And in the court, it was a close case if that's what they were thinking. And they were not given the opportunity, if they felt he was culpable, to go for manslaughter instead of murder. They only had murder as a choice.
Counsel, how does the girlfriend's testimony about the argument in the hallway support the giving of the instruction when she went on to testify essentially that the defendant wasn't even there? So if the jury had accepted her testimony, they would have acquitted the defendant. It doesn't support the manslaughter instruction as far as I can tell.
He was not she testified that when she looked out the window, he was not standing with.
Right. So her testimony,
which is the same as, the same as Fuller, because Fuller put him there only once when he walked up the driveway, made that statement, and walked back down. So Yvonne Pierre essentially corroborated, or she contradicted Bates, who had him my client standing at the car the whole time.
I thought she testified that, I might be wrong, but I thought she testified that he left and then came back with food or something along those lines. Is that
the testimony was that after the shooting, the defendant drove the shooter away. But the police come, the EMTs, and then a few minutes later, my client shows up, parks at the end of the driveway, and came up the driveway claiming that he was bringing food to his children. That's the reference where he left and he came back. On the second point, I would argue that there was absolutely no evidence that the defendant participated in any way in the separate offense of witness intimidation. It was a spur of the moment statement by the shooter. There's nothing that can be drawn from circumstantial evidence that the defendant knew he was going to do that or encouraged him to do it. And then the other position is that the shooter himself, to have made the statement, it was not witness intimidation because it was too remote from the witness function to hold him responsible under the witness intimidation statute. Excuse me.
Counselor, before your time runs out, could you tell us what exactly your client said in the suppressed statements?
In the suppressed statements, he gave information which allowed the police to identify Almanor and his telephone number, which led them to locate him by pinging his phone at another person's house.
But what did he say? Did he say Almanar is the guy in the car who jumped in the car after the shooting, or he just say, I know Almanar, he wasn't there, but I know this guy, and this is a picture of him, here's his cell phone?
I have to confess I don't know the answer to that. I rely on the transcripts for that.
That's fine.
Any questions? Okay, Mr. Shea, thank you very much. We'll put you on mute, but you'll still be visible to us. ADA Kenny.
Good morning. May it please the court, Jessica Kenny on behalf of the Commonwealth. Everyone can hear me, I assume?
Yes.
Okay, great. Judge Ditkoff, to get to your question right off the bat, the defendant's suppressed statement was eventually basically explaining the entire crime, admitting that he came to the scene with Almanor, admitting that he drove him there, admitting that they parked behind the car, admitting that they went inside, admitting that at first he went to check and make sure that his girlfriend and his kids were fine, and then ultimately observing Almanor retrieve the shotgun from somewhere within that second floor apartment. He admitted that he knew he was going out to confront him. He wasn't going to let him go alone to do that. He admitted that he went out with him to assist him, but that he didn't have any weapons with him except perhaps maybe a knife in his car. He admitted to watching the events unfold. He admitted to egging the events on, but not in the same way that the other two witnesses did. This defendant claimed that he only continued to tell Almanor that these are the guys, these are them, these are the guys that were here that were running through the house. He admitted to seeing the shot be fired and then said that Almanor got in his car. He admitted to driving him away. He told police where he dropped him off. He never referred to Almanor by name. He only knew him as by nickname, but he did provide the police his phone number. And the entire statement did not come out that way at first. As you know from what he said at the scene, he distanced himself. And at the very beginning of the interview, he distanced himself as well. And as police began to tell him about the other people they were interviewing and the information that they did in fact know, he was more and more revealing each time essentially they asked a question. It didn't all come out that way at first. So I hope that answers your question, because I know it's not part of the record because the transcript of it was an exhibit in the motion hearing and obviously not marked for identification at the trial. But if your honors would like a copy, as I indicate, the interview and the transcript were marked at the motion hearing, and I can certainly assist with the clerk's office in Plymouth to make sure that that gets to you if you would like to review that in its entirety. I'd like to turn now to counsel's argument that it was error for the judge not to give the involuntary manslaughter instruction. And I think right off the bat, the biggest sort of issue I have with the argument is he says they weren't given the opportunity to consider involuntary manslaughter. And we really need to think about how it is that we ask juries to determine whether a lesser included fits. We don't give the juries the instruction for murder, instruction for murder 2, and the instruction for involuntary manslaughter and say, here, you choose which one you think fits best. That's not how we ask them, and that would be improper. We start with the greatest offense, and we tell juries every time, you must find the defendant guilty of the highest offense that you find the elements are met. And in this case, this jury took that instruction for murder in the first degree, and they obviously found that the Commonwealth didn't meet one of those elements beyond a reasonable doubt. So they moved on to second degree murder. And then they found beyond a reasonable doubt that the Commonwealth established each and every element of that offense. And that's why it's important, I think, that counsel is not suggesting that there's insufficient evidence for murder 2. He's simply saying the jury should have had the option to pick between those two. And that is never how we would instruct a jury to consider a lesser. And they would not be permitted to find the involuntary manslaughter to even get to that portion of the instruction if they didn't find the malice necessary and all the elements of murder in the second degree. And so I think that that is very important here. And that's, I think, what Judge Shin sort of realized as these arguments were being made to him with regard to whether or not this involuntary manslaughter instruction should be given. The Commonwealth's theory was that the defendant was a joint venture in this murder, and that he acted in some agreement with Mr. Almanor, because we know obviously this defendant didn't have the murder weapon, didn't pull the trigger. The defendant is now trying to say, well, they also should have been able to determine if as a sole actor that he acted with this intent for the involuntary manslaughter. And so think about how that jury instruction would have even read. It would have said, if you don't find murder in the second degree based on joint venture, I now instruct you to consider involuntary manslaughter, although the joint venture doesn't apply to that. It would have been very confusing, and it would have put before the jury another theory of the case that the Commonwealth was not advancing. And Judge Shin makes that very interesting statement. He says, look, if they find he was in agreement, if they find he was working with Almanor towards the murder, he's guilty of murder. But if they don't find that he was in that agreement, he's walking out of here. And so that was, at that point, when it was put to him that way, why defense counsel ultimately decided that he didn't want the involuntary manslaughter to go before them, because it put another theory of the case that was not based on his joint venture actions with Almanor before the jury, and it gave them that option. Whereas if they didn't find murder in the second degree, They would have had to find him not guilty of any murder. And his entire case, from the way he cross-examined the witnesses all the way down to the closing argument of defense counsel, was not that, oh, he was just trying to scare him, or, oh, you know, what he did really only amounted to wanton and reckless conduct. His argument to the jury and his theory of the case was this didn't happen, that the two eyewitnesses that claim he egged him on and he engaged in this agreement with him are lying. You shouldn't believe them. My client was just present. And so there was a benefit to the defendant to taking that stance. He chose that stance, and there was no substantial risk of miscarriage of justice, because in this instance, the jury found second-degree murder, and there's no allegation that there is insufficient evidence to support that, just simply that they should have been given this other option, but we would have never instructed them to deliberate that way about this particular lesser included. With regard to counsel's argument that there was insufficient evidence for joint venture for the intimidation of a witness, I suggest to the court, obviously we're talking about the conduct of Almanor at the time that Derek Fuller goes to reach for the door handle and get out of the car. The entire purpose of Mr. Tassie's participation in this crime, his whole role, if you will, was to prevent detection, to allow the crime to be committed, to allow to be there and available to assist. And this is all evidenced by him acting as the lookout, being at the end of the driveway, him speeding things up when it's taking too long. Even after the shot is fired, there was testimony that Mr. Tassie's statement to Mr. Albanor was, hurry up, let's go, let's get out of here. Again, encouraging them to get out of there. So when you look at a whole, at everything that Tassie was doing in his entire role, it's clear that the purpose of him even being there was to assist the crime being committed and avoid them being detected. And that's exactly what happened. Fuller wasn't able to get out of the car. Now, nobody knows if Fuller was going to actually go for help or go try to help his friend or try to alert the authorities, but certainly that is what the Commonwealth's theory was. He wasn't allowed to testify specifically at trial about what his sort of intent was when he went to get out of the car, but he sat there while his friend just had a shotgun shot at his chest, and he goes to get out of the car.
If the defendant's intent is to avoid detection, that's not the same thing as to prevent future testimony. That speaks about what's going on in the present, not what's going on in the future.
So it is, in the McCreary case, it is enough to discourage communication to investigative authorities related to the crime. And I would suggest that in this particular situation, that the longer they can delay the police from being called and the report from being made, the better off these defendants are as far as being able to get away with this crime and perpetrate this crime. Certainly, if someone could have called 911 or did call 911 while Almanor was still there with the gun, or Tassie's car was still blocking the other car in, it certainly permits investigators to gather evidence that they would not have had if the defendants can successfully delay the police being called. And even if that delay is momentary, as it perhaps was in this case, it did in fact allow the defendants to get away. And it did allow Almanor to go undetected for several hours, and had Tassie not come back to the scene, it may have also permitted him to. It allowed the murder weapon to get away from the scene. As you heard in the testimony, there was significant rain falling. So even with the delay, some of the evidence got washed down the driveway. There certainly was an intent on both of their parts, I suggest, from the evidence to delay Mr. Fuller from getting out of the car, and that assisted them in being able to commit the crime, and that assisted them in prohibiting him from communicating to investigators what he knew about the crime.
Counsel,
I mean, the threat itself, I'm sorry, go ahead.
Counsel, what's the most similar case factually that you can cite for us?
I think it's Burt that is in my brief. That's the attempt to deter future communication, and that would satisfy the statute. And so I think I definitely cited Burt in my brief. I think that's again.
What was the statement at issue in Burt, if you recall?
I'm sorry, I don't recall. If you'd like, I certainly can submit a letter to the court.
That's all right. So Burt is the most similar case.
That's the case that deals with intimidation handling or intimidation of a witness being the deterrence of future communication with the police. And so certainly a threat like that being made not only delays the police from being called, but certainly is arguably going to weigh on a witness's mind when the police inevitably do arrive, whether or not to cooperate with the police. We're just threatened that if you get out of the car, you'll be next. So I suggest that that's certainly a fair inference from the type of conduct that these two engaged in that day. Would the court like me to address the closing arguments? I know counsel did not address it in his argument, but it was raised in his brief. If there are no further specific questions, I would be happy to rest on my brief and yield the remainder of my time.
I see none. So thank you both for participating in this sort of unusual and novel experiment that we're doing here, but I think you both were able to make your arguments and we understand them. So thank you both. Both of you stay healthy and have a good weekend. And with that, we'll take the case under advisement. 2020. I'm Greg Massing, and with me today are Justices Shin and Ditkoff will be your panel for today. As you know, we are doing this argument on Zoom, being live streamed on the Appeals Court YouTube channel. Notwithstanding, we'll follow the same rules as in a regular courtroom, 15 minutes per side, no rebuttal. Only one advocate can speak at a time, and so the clerk will mute the other one while you're not speaking. However, we're still able to see you, so please keep any gesticulations or reactions to a minimum. It can be very distracting. Once we get going, there will be a 15-minute countdown clock, and this proceeding is being recorded and will be archived and available to the public as any oral argument would be. If we have a technical problem with Zoom, we might have to suspend the session. Hopefully that won't happen, but we'll let you know if it does. We might have to put you in the waiting room. As always, we have read your briefs. We're familiar with the case, so you can go right into your argument. And although you're free to use all 15 minutes, we won't hold it against you if you finish up earlier. And so I'm going to call the case, which is Mariano versus Town of Needham, 19P 723. And I think Mr. Caniff, you're the appellant.
Thank you very much, Your Honors. Good morning. My name is John Caniff. I'm here today on behalf of the workers' compensation insurer, the Town of Needham. We've undertaken an appeal of the reviewing board decision that has invalidated our issues that we raised before the administrative judge in the original hearing that proceeded along the lines of a discontinuance complaint. What I find most disturbing about the reviewing board decision is that they have basically decided to void ab initio the filing of our complaint back in September of 2014. They stated that our report from Dr. Milo Pulde only contested initial causation and was not, therefore, since we were unable to contest initial causation on this case at that point in time, having already taken a hearing decision and not taken any further appeals, that we were precluded from even bringing the case. And the two other issues that we raised, most significantly, the timeliness of the submissions by Employees Council in support of their claim, and the fact that Dr. Kendrick had failed to, Corrick, I'm sorry, had failed to examine the employee at any time prior to 2015. So I believe, and it's our contention, that the reviewing board violated the standard of review, engaged in illicit fact-finding by making a determination that Dr. Pulde's report was insufficient, and basically asserted or dismissed the case without considering the issues that we had raised.
Don't you have to prevail, don't you have to show either that she's better or that whatever is ailing her now was no longer caused by the exposure as a teacher?
And we had done that, Your Honor. And as I said in one of the footnotes of my brief, there were 5 reports issued by authored by Dr. Milo Pulde that were all submitted into the record. They're contained within the record appendix, pages 247 through 332. And Dr. Pulde's opinion, as referenced by the administrative judge in his hearing decision, which is found at record appendix page 37, only Dr. Pulde found her capable of returning to work. We certainly met our burden of showing a change in the employee's condition, sufficient to step into the forum and contest her continuing entitlement to weekly benefits.
But there is evidence on which the administrative judge could have found otherwise, right?
Otherwise, in what regard, Your Honor?
That there was evidence that would have allowed the administrative judge to find that there was no significant change in her symptomology.
That gets to the second 2 parts of our appeal, Your Honor. We certainly contested that Dr. Korek's opinions were sufficient because she relied upon the debunked diagnosis of multiple chemical sensitivities. Now, if you read Judge Bean's original hearing decision, both in 1998 and now more recently now in 2017, there's basically an alphabet soup of various diagnoses that define the constellation of symptoms that the employee is experiencing, but none of them are accepted in the legal community and are sufficient to warrant or upon which to rest an award of benefits.
So, Counselor, since Dr. Pulde, his principal diagnosis is idiopathic environmental illness or multiple chemical sensitivity syndrome, why shouldn't his report be struck for diagnosing the same thing?
He found her capable of returning to work, Your Honor.
But if you say anyone who accepts multiple chemical sensitivity as an opinion is garbage, then why isn't that? And so did Dr. Robert Swatinsky too.
Because neither of those diagnoses provided by either physician, Your Honor, are accepted diagnoses to warrant an award of benefits. They don't stand up to Daubert or Lanigan tests.
But there's already an award of benefits. You're the one who has to change things. You have the burden of proof, didn't you?
Exactly, Your Honor. And we did.
So if all the experts in front of me diagnose idiopathic environmental intolerance, or multiple chemical sensitivity, and you say if you diagnose that it's of no value, then is there anything in front of the administrator?
Dr. Korek provides that same diagnosis, Your Honor. And if that diagnosis is of no value to the employee in supporting her case, and the judge adopted Dr. Korek, then it's invalid.
But if all the expert opinions are invalid, then doesn't the benefits continue?
No, because the employee has been put to the test of having to show continuing causal relationship.
So you're saying it's the employee's obligation on your motion to discontinue to show that she's still entitled to benefits and it was caused by the environmental exposure as a teacher?
Yes. We described that in our brief via Spinatsky's and Josie's case, Your Honor. The employee has the burden of proof on each and every element of her case. The 2 elements of this case were causation or continuing causation and present incapacity for work.
What were those cases again?
Spinatsky and Josie's case. They're listed in our brief, Your Honor. Once we started the process of filing the discontinuance complaint back in 2014, the employee was on notice that she had to prove her case. And one of the contentions that we have in this case is that at no point in time did the employee provide a report substantiating her case until after the record had closed on July 21st of 2017. If you take a look at Dr. Corix's first report, which was July 24th of 2017, Record Appendix 426, that was submitted 3 days late. Now, I know the administrative judge in his hearing decision says I let things like 3 days go, no big deal. But that report described the diagnosis of multiple chemical sensitivity, which has been debunked as a supporting diagnosis. We objected to the submission of that report.
I'm sorry to go back, but I'm not seeing Spinansky or Josie's case in your table of authorities. Could you give me a site? Or at least spell them?
Sorry, excuse me, Your Honor, I have it. Josie's case is 324 Mass 415, 1949. Spinatsky's is 220 Mass 530, 1915.
What did you say? Could you read that again? Spinansky was
220 Mass 530, page 530. The 1915 decision, Judge. It's well cited for the proposition that the burden of proof is upon the employee to prove each and every element of her case.
But if you were the one seeking discontinuation of the benefits, do you agree that you at least had some initial burden to prove a change in symptomology?
And we did do that, Your Honor.
Okay, no, I'm just asking about the burden. So if that's the case, the administrative judge found that regardless of whatever diagnosis you put on her condition, that the administrative judge was crediting her testimony that she continued to suffer the same symptoms to the same degree that she did at the time that he issued his original decision. So how is that clear error or abuse of discretion?
Your Honor, expert medical opinion attributing the diagnosis is required. The employee can testify that she has the continuing symptoms, etc. We are dealing with a psychosomatic illness here in large part. Excuse me. The employee's testimony that she continues to suffer from the same symptoms is not sufficient to carry the day for her.
Why not? Then why is it, aren't you essentially then just relitigating the original decision that found a causal link between her symptoms and the workplace incident?
Well, we provided a report from Dr. Pulde that said otherwise, Your Honor, that she was no longer disabled, that she could certainly work as a Spanish teacher as she had previously.
I have a question about something you say in your brief. You say on page 13 that by failing to object to the judge's statement of the issues, the employee waived her right to argue on appeal that the issue of present disability was not before the judge. It wasn't her appeal, though. It was your appeal, right?
No, exactly, Your Honor. We were the precipitant at each and every step of this case. But the reviewing board in their decision states that the insurer should never have even brought this complaint because their initial report from Dr. Pulde was insufficient to contest the case. However, as I referenced in my brief, when we went to the conference, the Section 10A conference in February of 2015, causal relationship and present disability or incapacity were made issues. They were raised. We took an appeal. We went to hearing. At hearing, and if you look at the hearing forms that were submitted by both parties, and as indicated in the administrative judge's hearing decision, work capacity and causation were both made issues and contested throughout the hearing process. If the reviewing board wants to state that we should never even have gotten in that bad at this case, I make an argument in my brief that basically the issue of the employee's present incapacity levels was tried by consent. At no point in time did the employee or her attorney argue that we were precluded from bringing the case. Are there any more questions? I'd be happy to concede the rest of my time.
Seeing none, thank you very much, and we'll hear from counsel for the employee.
Good morning, Your Honors. May it please the court. My name is Alan Pierce. I represent the employee appellee, Linda Mariano, in this case. I'd like to just point out a couple of things I heard from brother counsel in his argument. He indicated, first of all, that Dr. Polde found that she was capable of returning to work as a Spanish teacher. If you manage to weed your way through the 4 reports from Dr. Polde, which are quite extensive, total of 89 pages, largely single-spaced and underlined, very difficult to read. But Dr. Polde didn't really say that. First of all, in his first report, which triggered the filing of the complaint to discontinue, the report of July 13 of 2014, which begins at page 247 of the record appendix, you will note that he did not personally examine my client, which I think goes somewhat to brother counsel's argument that Dr. Korick, who did telemedicine with my client, that her opinion should not count. He never examined her, and he basically at that time, if you read his report, he essentially says, if you get through the 43, 47 pages, that she never suffered a work-related exposure. He was unaware, and if you go through his lengthy report, he was unaware of the prior hearing decision. He doesn't reference it, and Your Honors are quite correct that Mr. Caniff's argument would be at least more cognizable if this were the original hearing that was done back in 1998. At that point, that was the same issue. The expert opinion in that case from Dr. Aceta on behalf of the town of Needham was essentially same of Dr. Polde's. He was basically saying there's a lot of psychosomatic stuff going on here, etc. Could be occupational illness, could be latex allergy. He postulated a variety of things. But at the end of the day, Judge Bean, back in his initial hearing decision, found Dr. Hu and actually it was Dr. Hu, credible. He was the treating physician, that she suffered from a chronic environmental illness. Now, when Dr. Polde suggested she wasn't disabled, if you really parse through his wording, he says she's not disabled to a work-related exposure. He then goes on to indicate that she has severe disabling or debilitating symptoms, and he outlines them, that they're diverse, severe, debilitating. However, he feels that the magnitude of this disability is psychiatric. So he's not saying she isn't disabled. He's saying she isn't disabled due to a work-related condition, which he opined was never work-related. So the fact that this original decision of Judge Bean was unappealed in 1998 establishes, for better or worse, that she suffered indeed, whatever you call it, whether it's MCS, which...
Counselor, do you...
Yep, go ahead, sorry.
Does that mean you disagree with your brother's assertion that you had the burden of proof?
On which issue, Your Honor? On issue of causation?
Yeah, on causation, on current symptomology. What do you do the burden of proof on?
My burden of proof is to prove all elements of the claim. However, at the posture of this case, where causal relationship had already been proven, and the insurer files a complaint to discontinue on the grounds that causal relationship was never adjudicated, they have a burden of showing that something else has changed in the interim 22 years to now account for her symptoms. And nowhere in the 86 pages of Dr. Polde's 4 reports is there a suggestion that something else other than the exposure to the noxious elements in the workplace now control whether she's disabled or not. He postulates that it would be psychosomatic or psychiatric, the exact same postulate that was made and rejected the first time. So,
go
ahead.
Here's what I don't understand. if they have presented a triable case that she's better, that she can return to work, and let's say the administrative judge hears that and decides, no, she's not better, she can't return to work. Did the fact that they presented a triable case mean that you had to reprove that her disability was caused by her exposure as a teacher?
Yes. And we did, with the reports of Dr. Korick, who has been treating her for the last 20 years, since Dr. Hu retired and she took over his practice. So that then gets into the issue that Brother Counsel has raised as to whether or not Dr. Korick's opinions that were expressed in her letters should have been considered by the judge. So if you'd like me to address that argument, which is contained in both our briefs, I'd be happy to.
So let me ask this, since that's not the grounds of the reviewing board, if we decide the reviewing board was wrong, that the town did not meet its initial burden, can we then go on to consider whether Dr. Korick's report was properly accepted, or do we have to send that back to the board to reconsider it first?
There's two ways to answer that. First of all, I'm not sure the reviewing board really considered it. At the end of their argument, they felt so strong that the reviewing board cases prior of similar cases indicated that the insurer did not meet its burden of proving a change in condition or the diagnosis. They addressed Dr. Korick's reports, essentially saying, we're not going to get to that. However, if we were to get to that, we consider it harmless error. But as you can see in our briefs, Dr. Korick and counsel stated the medical record closed on July 24, 2017. That's correct. But the record of this case, the actual concluding time before the judge was going to begin to write a decision, was in November of 2017. So
my question is,
yeah,
can we decide whether it was appropriate to allow in Dr. Korick's report?
I believe you can.
We don't have to send it back to the board.
I don't believe so. We both briefed that issue. In our brief, we've given you adequate bases, both in the workers' comp statute as well as the cases about the wide discretion of a judge to allow evidence unless it is done in an arbitrary, capricious manner or as a result of, quote, whimsical thinking. Now, in this case, when we submitted Dr. Korick's report, counsel objected. We filed a response. The judge actually held a hearing on the record on the insurer's motion to dismiss. That is contained in the record appendix. There is a transcript of that motion. The judge wrote a decision on their motion and incorporated that finding in his hearing decision, in that as an administrative judge, it is frequent that reports and records come in and that he does not hold a particular date to be hard and fast, and 3 days to him made absolutely no difference. The record itself wasn't going to close for another 4 months or 5 months. He afforded the insurer an opportunity to fully argue the admissibility of Dr. Korick on the issue of it being late. He dismissed that out of hand, as did the reviewing board. And in terms of Dr. Korick's use of medical terminology, she explained that she uses MCS because that is a billing code in order to get paid. So some insurer recognizes that. So as a matter of convenience, she used the term multiple chemical sensitivity, but she went on in her addendum in August of 2017 to say that this is really synonymous with a chronic environmental illness, which every doctor in this case, Swatinsky, Dr. Pulday, Dr. Goldman, they all indicated that she does suffer a chronic environmental illness. And you will note Dr. Korick is a specialist in occupational and environmental diseases, Harvard medically trained, Brigham and Women, with a 40-page resume of peer-reviewed articles, et cetera, on this. So being 3 days late, I think is easily disposed of by Judge Bean's hearing on that and the reviewing board on that. So I think you have adequate basis.
Counsel, sorry to interrupt, but I just want to clarify your position. Are you arguing that the town failed to meet its initial burden of production, or are you arguing that the town met its burden, but when you satisfied your burden of proof once the burden shifted to you?
I am actually arguing both.
Okay.
I don't feel that they did meet their burden of production as outlined by prior decisions to show a change. And secondly, assuming that they did, We have produced competent medical evidence to the contrary, which an administrative judge and a reviewing board are free to adopt or not adopt. So
How does one meet that? How does one meet that initial burden? Is it by showing a change in symptomology or showing some sort of intervening cause? What would be sufficient to discharge that burden?
Oh, I would say a change in a history. Let's assume, for example, that her symptoms somewhere historically over the intervening 22 years had resolved, and that perhaps she was exposed to noxious elements out in her normal daily life. That's now accounting for things. In an exposure case, it's different. If we deal, for example, with a back injury that is found to be compensable, and then later on there may be history that the claimant employee might have changed a tire and reported to a doctor that her back felt worse, and an MRI showed a worsening of perhaps an underlying disc condition. But in this case, everything has been constant since back in the late 90s, right up through Dr. Polday's report. So yes, I feel they did not meet their burden of production, but even if arguendo they had, Dr. Corrick's opinion and rationale for that opinion meets our burden of showing that she continues to remain disabled due to a previously determined work-related condition.
Just to be clear, where the reviewing board says that self-insurer cannot contest the determination of original causation, that's wrong?
No, that's absolutely correct. They now cannot contest original causation. The time to do that was back when Judge Bean wrote his first.
I thought you said you had to prove every element of your claim.
Not original causation.
Right,
Continuing causation.
Continuing causation.
Original causation is that horse is already out of the barn.
You could rely on the original causation.
Absolutely.
One more question of clarification. The Judge Shin asked you what you were arguing. Judge Bean's decision, he writes, at the beginning of the general findings, I find there has been no evidence of a substantial change in the employee's symptomology. Is he saying that the town didn't carry its burden, or is he saying that they did carry its burden, but I'm looking at all of the evidence and the combined evidence, I find no change?
I think the latter, because there was an evidentiary hearing. So she testified again, by the way, outdoors on her brother-in-law's porch. And so he made a credibility determination that her description of her symptoms had not changed since his original hearing decision and her original testimony. And he buttressed that with the fact that her treating doctor for 20 years have also stated in her report her symptoms haven't changed. So that I am saying that it was supported by the evidence of the testimony of the employee.
Okay, so then what the reviewing board decides is different from that. They're saying it didn't even rise to that level.
That's correct. And I think if the reviewing board, and again, I'm postulating, said even if it did rise to that level, they would then dispose of the case because the judge was free to pick Dr. Corrick or Dr. Polday. They basically said, we don't have to get there. But I suggest to you, Your Honor, if you do get there, that somehow you feel that perhaps the insurer had met its burden by Dr. Polday's original report. The fact of the matter is, on the merits of the case, we've prevailed. We've introduced competent evidence, and the judge has made findings of credibility and fact that cannot be disturbed, absence of use of discretion or other legal standards. No further questions. I'll rest on my brief.
Seeing none, I thank you both for your arguments. We'll take the case under advisement, and thank you for participating in this unusual way. I think it worked pretty well, and we were able to definitely hear you and see you. So thank you. Have a good weekend. Stay healthy. Stay well. Argument session for May 15, 2020. I'm Greg Massing, and the panel today consists of me and Justices Shin and Ditkoff. As you know, we're doing this on Zoom and live streaming on the Appeals Court YouTube channel. We'll follow the same rules as in the physical courtroom. Each side has 15 minutes to argue, and we'll ask questions. I understand that the appellees have divided their time 10, 3, and 5, 10, 3, and 2. Only one advocate may speak at a time, and in fact, you will be muted when it's not your turn to speak. But except for Mr. Conti, we can see all of you. So if you're not speaking, try to keep your gesticulations and reactions to a minimum because they can be distracting. Once we get going, there will be a countdown clock shown. We're recording the proceeding and it will be available in our archives. If there's a technical problem, we might have to stop the argument and put you back in the waiting room. That hasn't happened yet this morning. So knock on wood. As always, we have read your briefs. We're familiar with the case. Although you're free to use all 15 minutes, or all 2 minutes, there's no rule that you use it all. So with that, I'll call the case, which is 19P1046, James Javarus versus Mark DiGeronimo and others. And we're hearing from the counsel for the appellant is Attorney Newmeyer, if I'm correct.
That's correct.
You have the floor.
Good morning, Your Honor. The question here is whether the Superior Court correctly granted summary judgment as to the undue influence and declaratory judgment claims in counts 1 and 2. There are other counts of the amended complaint, but there's no appeal as to any of that.
Can I just stop you real quick? Is the case fully disposed, or was this a 54B final judgment on a partial judgment? I'm not quite sure.
Well, we started with the 54B, and then after that, there was a resolution with respect to Mark DiGeronimo because of an unrelated case. And then there were some other dismissals, but
so the only thing left then is your appeal of counts 1 and 2.
That's right. That's right.
Okay. So go ahead.
I do note that Paul and Betty stated in their briefs that much of Javaras's statement of facts is untrue and irrelevant. Now, of course, whether it's relevant or not is up to you folks. Whether it's untrue, I submit as a question for the jury or the fact finder. And I know it's a voluminous record, and I'm sure you've read everything, read the briefs at least. But I do want to give you just a 120-second summary of some of the relevant facts. My client, James Cheverus, worked with Tony G. Geronimo, the patriarch of the Di Geronimo family, from 1981 to 1994 when he died. Cheverus persuaded 2 life insurance companies to reinstate $18 million in life insurance on Tony's life, which policies had lapsed because of premium non-payment. Even though they knew he had terminal cancer at the time of reinstatement, and they later paid the $18 million. We wouldn't be here today, none of us, if that had not happened. Tony repeatedly expressed concern to Cheverus about family dysfunction, and he wrote a letter, which is in the record, August 27, 1993, to his children about the family dysfunction. He decided to set up the trust, and he did not want the children to control the trust. When the original trustee, Agnes Cole, died in 2011, Cheverus became a trustee of the trust and assembled a team of competent professionals, which usually met quarterly. While he was trustee, the assets increased from 45 to 71 million, and $7 million was distributed to Geronimo family members.
Counselor, why does any of this matter? No matter how good he was before, that wouldn't prevent the grantor and the beneficiaries from firing him.
That's correct, except that undue influence cannot be used to terminate him as a trustee. That's the central question. It was clear
That's a threshold matter there. Do you have any cases where the issue of undue influence on a trustee is raised in Massachusetts?
It's very rare, frankly. But what happened here was extremely rare. This is a very unusual case. You have evidence of superior performance for years and years and years, and evidence that nonetheless, Mark wants to get him out. He's stimulated by his mistress. Paul joins him because Paul is accused of stealing assets, frankly. And Betty's daughter, in October 23, 2015, email to Bill Zorn of the McLean Law Firm, expressed concern that her mother is being coerced to remove Cheverus as trustee. Very unusual thing, not contradicted by Betty in her affidavit, by the way. She's also present at a meeting in June 2016 where there's an emotional screaming exchange between Mark and her mother, which results in her mother crying uncontrollably for several hours and then signing a purported removal of JAVARAS of the trustee.
This is Hussey you're talking about.
Tassie and Hussey.
Yeah, okay.
That's right. And Betty JAVARAS, it's very interesting to note that when she signs an affidavit, she doesn't contradict anything that her daughter says. Very unusual situation, suggests there's some family dysfunction. Now, I do think we agree on the standard for summary judgment, and we all cite the Flesner case, a case I argued 29 years ago. But that case, the holding says, in cases where motive, intent, or other state of mind questions are at issue, summary judgment is often inappropriate. Now,
so what about the ratification of the removal by the majority of the beneficiaries for the one trust and by Betty herself during this litigation?
All right, I was going to get to that last, but let me answer that question right now. Betty, I believe, concedes that the record indicates that JAVARAS did this on advice of counsel. JAVARAS specifically asked if he was breaking any fiduciary duties by using these funds, the $485,000 that was wrong. And both of his attorneys said no. Alexandrov writes him an email, July 8, 2016.
What? Just because your client maybe could legally take $500,000 from the trust doesn't mean that she can't fire him.
What the argument here is the undue influence claim has been rendered moot because he took the money. Now I say
no, not because he took the money, because she fired him again. Because she wrote an affidavit saying she signed a paper that says I want to remove him.
Yeah, I understand that. When I say that's what they claim, the moot is the word they use. Okay, that's in their briefs, the term moot. And this is the really important question in this case, is that when a trustee does what we ought to have a trustee do, that is consult with counsel about a course of action. And counsel says in an email, the beneficiaries may at some point try to claim personal funds should have been used to litigate the cases. Our opinion is different. Both the terms of the trust and the MUTC favor our opinion. There is always a chance a judge may find otherwise. However, we believe it is highly unlikely. Now, a judge did find it incorrect. And what did JAVARAS do? He immediately returned the $450,000. And what plaintiffs are saying is—
Counsel, can I ask it to you this way? So you no longer have there are no longer any claims for damages, right? So you're asking for declaratory and corresponding injunctive relief. So let's say this case goes back and the judge declares that Betty was unduly influenced in the original decision to remove JAVARAS. Then so what? There's a later ratification and removal. So I fail to see how there's anything left to be decided here.
Well, the later ratification and removal is because a course of conduct based on advice of counsel. And that is the key question in this case.
You're not challenging the later decision as tainted by undue influence. So regardless of what relief declaratory relief the judge enters on the only claims that are left, the later removal is still going to be valid. So, I mean, can you explain to us how the case isn't moot?
Well, that's the key question of the case, and I agree with that. And what happened here is there were allegations that JAVARAS had stolen money over the years. None of that was true. JAVARAS says, "Are you sure I shouldn't be using personal funds instead of this other stuff?" And they say, "Oh, don't worry, you're right, although a judge may rule against us." He follows that advice. We want to have a decision in this case that encourages trustees to follow legal advice. Sometimes that legal advice is incorrect. There's no question about that. But the idea that moots a claim of undue influence, I think is troublesome and is not good public policy. When the evidence is overwhelming that undue influence was utilized by Paul.
I mean, is there any way that your client could be reinstated as trustee when he, before the second firing, sued for money damages, all the beneficiaries that he was supposed to be looking out for?
I don't quite understand that question, Your Honor.
How can your client be reinstated as trustee when he has sued for money damages, all the beneficiaries that he's supposed to be protecting as trustee of these trusts?
Well, at the time suit was filed, it was not clear what was going to happen in terms of where the money was going to go. It was clear that Paul and Mark had wanted more money than they were getting. And now he's removed after resisting those requests for years. And what's going to happen? Who knows what was going to happen? As it turns out, nothing's happened as long as this case has been pending. But if this case had not been brought, it might have been quite different in terms of what happened to that money in the trust.
But you brought the case.
Well,
not you. Your client brought the case,
right,
suing all the beneficiaries he has a fiduciary duty towards.
Well, he has a fiduciary duty to the trust. And to the extent the beneficiaries want something that the settler of the trust did not intend, which was the case here, a fact finder could find, he does not have an obligation to say, okay, we know your father wanted something else, but if you say you want some more money, I'm just going to give it to you. We have a slight difference of opinion, I believe, in terms of what Paul and Mark think about the duties in that respect.
But Judge Shin said this, I just want to clarify. Once the litigation got going, there's a document signed by 6 or 7 of the beneficiaries, and as well as by Betty, that says, I've lost confidence in JAVARAS.
Yeah.
You're not saying that that was subject to undue influence?
Well, I think that that does not moot the undue influence claim, and the fact that Betty.
But that itself you're not saying that act itself was also subject to undue influence. At this point, we're in litigation. She's represented by counsel. That was her free will, and she's competent to do that.
Well, I don't agree with that in the sense that she says in her affidavit, I became dissatisfied with JAVARAS over time. She never describes anything that JAVARAS did that made her dissatisfied. There's no evidence that he ever did anything that made her dissatisfied. Indeed, while the children were getting 17 million, or 7 million, excuse me, not 17, her monthly benefit went from 10,000 to 25,000. What is interesting, the fact finder could find is Mark and Paul kept accusing JAVARAS of stealing money. Betty never says that. Now, at the time that Betty signs the affidavit, they've had all the financial records. They can check into whether there's been any mismanagement or stealing of money or anything like that. And if there had, boy, that would have been in the affidavit. That's non-existent. So I think the fact finder could find that this second affidavit was just an excuse to say, okay, we're going to make the undue influence claim moot, and therefore you don't get to litigate that. You don't get to litigate that. But I do agree that's the most important question presented in this case. And none of us have any case in Massachusetts or elsewhere in the United States that's really directly on point. But as a matter of public policy, I think that my client did the right thing. He asked, is this okay? Would this be a breach of fiduciary duty? Should I use personal funds? And his lawyer says, no, don't worry about it. We've read it. And the judge may disagree, but we think we're right.
So isn't it okay for Betty to say, yeah, he consulted counsel, but I'd rather have a trustee who, in that situation, chooses to use his personal funds to sue me rather than my funds to sue me?
That's the question. Should the undue influence claim be precluded because of that? And it seems to me that if the advice has been don't take the funds, it would be really easy to say, okay, you didn't even follow your lawyer's advice. But when you do follow your lawyer's advice, sometimes lawyers are wrong. You know?
I don't understand why some outside lawyer's opinion is relevant to whether there was undue influence on Betty. She didn't read this lawyer's report, did she, before she made these decisions?
Oh no! Oh no! Well, I guess the point I'm making is, if she'd had undue influence before, there's little reason to think that that had not persisted in light of the conduct that is described by Cheverus in his brief. In other words, he had performed quite well. He had done quite well for her, and so forth. And according to her daughter, she was very resistant to removing Cheverus for a very long period of time, but finally broke down as a result of harassment and undue influence by her brother. If a fact finder credits that, it seems to me that this last item that happens doesn't preclude an undue influence claim being made. But I agree that's the critical question in the case, the most important question. And we do not have any case in the United States or in Massachusetts directly on point.
So your time is up, but I've got one more question for you.
Sure.
And answer this as briefly as you can. The judge says on summary judgment that rather than suing the beneficiaries, your client should have filed a complaint for instructions. What's wrong with that, if anything?
Well, the complaint does request declaratory relief, which in substance is the same thing. I mean, that's. So your answer is that's a form over substance. Yeah,
distinction.
that's my answer.
Okay.
All right.
Thank you.
Okay.
Thank you for your argument. So now we have Attorney Holmes with the first 10 minutes, and let's get get the clock up. Hold on a sec. Okay.
Thank you, Your Honor. May it please the court. The issues before you are best considered if we look first at Cheverus's removal of the 3 trusts established by Betty DiGeronimo, and then his removal as trustee of the trust established by Anthony DiGeronimo. On July 5, our office communicated to Mr. Cheverus that he was removed as trustee of the 3 Betty trusts. It is true that there was some conflict in the family concerning Mr. Cheverus's involvement in family affairs, but the key to the analysis, as the comments from the bench, I believe, reflect, is really what happens next. So Cheverus now is the removed trustee, and he contests he's validly removed without approval from the court or approval from the beneficiaries. Takes $75,000 from the 1996 Betty Trust on July 18, $25,000 from the 2011 Betty Trust on July 20, $69,000 from the 1996 and 2011 Betty Trust on July 28, and $150,000 from the 1996 Betty Trust on September 6. He helped himself to $319,000 to fund a lawsuit to sue the beneficiaries. He may have a great legal malpractice claim, but he breached his duties to the beneficiaries. On July 29, he sued Betty, and he sued other members of her family, asserting numerous claims for money damages. On September 29, I forwarded to his counsel a report from Robert Ditkoff at Harvard Law School that went through the complaint and said there is no basis in American jurisprudence to be suing the beneficiaries for money damages. If he was getting bad legal advice before, he should have gotten a new lawyer. I demanded that he drop.
Okay, interesting in there, that report, he did seem to acknowledge that there is a possible claim for undue influence in removing a trustee.
You know, actually, I don't think anybody has ever contested that a trustee could bring to the court an issue for declaratory relief or for instructions if the trustee legitimately believed that, you know, his removal was not appropriate. I don't think anybody has contested that. In fact, what we were moving for on summary judgment was that he was validly removed. We were ourselves affirmatively presenting that issue to the court. So I don't think I think that's a complete red herring. So, you know, when I forwarded the Ditkoff report, I demanded that the litigation be dropped. I demanded that the funds be returned. He did neither. And on the same day that I sent that report, Betty was evaluated by Dr. Mark Greenberg at Harvard Medical School. He found that she was highly capacitated and found that she was firm in her conviction that she had acted with independent mind in removing Mr. Javaras. So we have her now in a controlled clinical setting, alone with Dr. Greenberg. Mark DiGeronimo's not there. Paul DiGeronimo's not there. There's nobody to influence her. And what does she do? She affirms, she ratifies that she wants Javaras gone. On October 6th, Mr. Javaras was removed as trustee of the Anthony Trust. And then 6 days later, he amends his petition to add that as to contest that and add that to his declaratory relief. But he doesn't, even though he now has the Ditkoff report, he doubles down and brings even more claims. He ups the hostility against the beneficiary, and this time, incredibly, brings a RICO claim against the family. So then we get to November, and Betty, along with the other beneficiaries, signs the beneficiary majority affidavit, which recites his taking the money, recites his suing them, recites his hostility as the grounds for which they're, you know, that they don't trust him and they want him gone. And then we get to December, and Betty signs.
Can I stop you there?
Absolutely.
On the beneficiary majority affidavit, as you said, that would seem to have some relevance for the Anthony Trust, which required a majority, but why is it relevant for the ones where Betty can do it on her own?
Well, because what I'm walking through, Your Honor, is the chronology of ratification by Betty. And so she signs that, and that the beneficiary majority affidavit covers all the trusts. It covers the trust, her 3 trusts over which she has a power of removal, as well as the Anthony Trust, over which a beneficiary majority has a power of removal. So it's just another ratification by her. And then we get to her summary judgment affidavit, which is just her. And she recites, you know, again, that she's furious with Javaras and she wants him gone. And throughout this entire process, I represent her, our office represents her. We represent nobody else in the litigation, nobody else in the DiGeronimo family.
Sorry again. The last time she says she's furious, where is that in the record? I missed that.
Oh, that's in her affidavit that is submitted with our motion for summary judgment.
Okay.
She has a separate affidavit in that submission. So, you know, our pleadings on her behalf, and there's no question she's capacitated. Our pleadings on her behalf over and over again ratified she wanted Javaras gone. And there's also correspondence that's in the record from me to Javaras counsel affirming that as well.
So are you saying even if there's a genuine dispute about whether she was unduly influenced the first time, prior to litigation, that's mooted because she's not unduly influenced in the subsequent ones?
That's exactly what I'm saying, Your Honor. I think that there was a very easy route for Judge Reardon, and we tried to lay that out. And during this period of time, there is no evidence at all that Betty or anybody is influenced by anybody, let alone unduly influenced. And we've got this pattern of conduct, this hostility to the beneficiaries, so that removing him, makes eminent sense. In fact, he's breaching his duties by, proceeding with this litigation. Now, with regard to the Anthony Trust, and I think it needs to be taken separately because he's removed from that, not back in June with, or July, with the Kathy Hussey, sequence of events. He's removed from that trust in October. after he's already suing the beneficiaries. This trust, like all the other trusts, has no for-cause removal provision. But even if there was plenty of cause, because by the time they remove him on October 6th, he's already taken out of that trust to fund, his war chest to sue the family $150,000 while he's trustee. And then he's also suing everybody. And then again, after he's removed, he amends and, ups the ante and brings even more claims.
Can I ask you why on the issue of, you said at the outset that he could have brought a complaint for instructions to resolve this issue. What difference does it make whether he puts it in a complaint for instruction or in a lawsuit? A complaint for declaratory judgment.
I agree with the colloquy that you had earlier with counsel that that's an issue of form. I don't think that makes a difference. It was suing the beneficiaries for damages that was the problem. But and they're free to remove him for whatever reason, because they just don't like him anymore. That they don't like the way he looks. I mean, there are plenty of reasons, but there were lots of compelling reasons here. I think the key passage from Judge Reardon's order is, quote, page 6, over time, she became unhappy with the service, which culminated in outrage when JAVARAS initiated this litigation. Since he filed his claims, Betty and a majority of the beneficiaries for each of the trusts renewed their decision to remove JAVARAS. I mean, the evidence supporting that is undisputed. On behalf of Betty, I ask you please to affirm, and thank you very much for your attention.
Thank you. Judges Shin and Ditkoff, do you have any questions for Ms. Jones? Okay. So, Mr. Centerfit, you're next. You've got 3 minutes. We can't do 3 minutes on the clock. We're going to do 5 minutes. So at 2, you need to stop.
Okay, I will, Your Honor. Good afternoon, Your Honors. May it please the court. Marshall Centerfit on behalf of Paul DiGeronimo and Geronimo Properties, Inc. I will not rehash all of the arguments here, and I don't have the time. I will highlight a couple of points that are also in our brief. This case does, as the panel, I think, questions reflect, and as Attorney Holmes argued, really begin and end with the ratification. There simply are no arguments at all that would undo the ratification. There are no arguments that the ratification was the product itself of undue influence. I think the panel has pressed on that issue, and I think that there's an acknowledgement, which is the only acknowledgement that we can have based on the papers, which is that Mr. JAVARAS does not argue that Betty's participation in this case or that her ratification and the events surrounding the ratification were themselves the product of undue influence. This is an unusual undue influence case in that we have the alleged victim participating. Oftentimes, undue influence cases concern a decedent or perhaps a person with incapacity. Here, although the ratification in of itself is more than sufficient to uphold the Judge Reardon's decision, and there is no error shown that would undo that decision, it also should be said that his determination, and he says this in his decision on summary judgment, that Betty negated the allegations of undue influence. Judge Reardon clearly found her participation in this case to contradict the allegations in the complaint, which Judge Reardon also, by the way, found were insufficient under the pleading standard in and of itself. But even if he hadn't made that finding, or even if an error could be claimed as to that finding, he separately noted that her participation in the case, including the affidavit that has been discussed at length here at today's argument, was sufficient to negate the claims. To prove undue influence, you have to show that somebody was susceptible. You have to allege that it was susceptible and that it occurred. And what Judge Reardon found is that it did not. The other point that I would make is I agree that the reference in the discussion of the petition for instruction by Judge Reardon. I believe it was really in response in addressing the fact that the trustee here was seeking money damages, and Judge Reardon was opining about what would it be the proper procedure if a trustee had a legitimate concern about removal. And with that, I see that my brief time is up. We rest on our papers, Your Honor. On behalf of Paul DiGeronimo and Geronimo Properties, Inc., we encourage the court to uphold the lower court's decision. Thank you very much.
Thank you. Mr. Conti, let's put you on mute. There you go. And we can see you now.
Thank you. Thank you, Your Honor. Your Honor, I represent the successor trustees, Cynthia Stenitis-Dade and attorney Steve Nottinger. My comments would be repetitive of my colleagues, so I will not rehash what they have said. I will rely on my papers and the words of my colleagues. Subject to your questions.
Yeah, can you explain or give the basis why appointing your clients as successor trustees is not a what do you call that? An unnatural disposition?
Well, Your Honor, I think the contention is, so let me just jump to the ratification. Cynthia Stenitis-Dade was appointed with respect to 3 of the trusts, I believe, in the vicinity of July 5th, 2016. And that was completely appropriate. It was the decision of the grantor of the trust. That was Betty. She made that decision. With respect to the other trust, Steve Nottinger was appointed. And that required, I believe, an attorney at that point in time. And all of these acts, Your Honor, as my colleagues have pointed out, were ratified. In fact, Mr. Neumeier, in his brief, doesn't even contest, doesn't even claim that Betty was unduly influenced or anyone was unduly influenced with respect to the ratification. He hasn't even argued.
Right. Just you got, the clock is wrong. You got 17 seconds. How did Betty know your clients?
My client had a relationship with Cynthia Stenitis-Dade for many years before this. She was actually the person who was actually administering the trust, had worked with Mr. JAVARAS, and was really the person behind the scenes who was managing the 3 trusts. Attorney Nottinger was an independent party who was brought in for this purpose by and through Mr. Holmes's firm.
Okay, thank you. Any other questions? So that went very well for under the circumstances. Thank you all for welcoming us into your homes for this argument. We will take this under advisement and wish you all health and stay out of trouble and stay safe and have a good weekend.